Rebuilding a relationship with an estranged family member following a divorce is a process of navigating deep emotional complexity. Often, the only remaining link is a digital one. When years of silence are involved, these digital connections are fragile. If old grievances resurface, the communication line becomes strained and frequently breaks. A parent's natural instinct is to fix that break by reaching out more frequently. However, in the UK, these persistent attempts to check in can result in a formal police warning for harassing your own child. We will define the specific legal boundaries of family communication and the steps required to de-escalate these digital conflicts. Navigating a volatile family dispute without an understanding of these laws turns emotional pain into a prosecutable criminal offense. The law recognizes a specific situation that catches many families off guard: unintentional harassment. You do not need to be malicious to cross the legal threshold. A pattern of communication is considered harassment the moment the contact causes documented distress to the person receiving it. UK harassment law operates on a specific standard. The sender's motivation is secondary to the receiver's experience. Messages driven by parental love or a need to repair a relationship lose their legal standing the moment the recipient explicitly states the contact is unwanted. In the eyes of the law, the recipient's documented distress supersedes the sender's intentions. To see how this applies to real families, we will look at a case involving a mother named Molly and her estranged son. After 5 years of silence following a divorce, Molly received a police warning. Her son had filed a complaint stating that her attempts to contact him constituted harassment. Molly wanted to understand the complaint and settle the dispute, so she sent him a social media friend request, which he accepted. The communication that followed was erratic. Her son sent hostile late-night messages, fluctuating between demanding she leave him alone and telling her he missed her. Because of this confusion, Molly continued to message him to verify her welfare and check on how he was doing. Legally, her persistence was the problem. Because the son had previously expressed that the contact was unwelcome, Molly's messages were causing him distress. Confusing or contradictory replies from a family member do not grant a sender legal permission to continue messaging. When accused of harassment, family members often make one specific error: the last word mistake. There is often a strong drive to send one final message to explain your side or clarify your intentions after being asked to stop. Indulging this urge can escalate the situation. A single follow-up message can turn a police warning into a formal cease and desist letter or a court injunction. To prevent escalation, you must follow the stop rule. This means you must immediately cease all direct communication across every digital platform. Initiating digital silence is a protective action. It is not an admission of guilt, and it does not mean you are abandoning the relationship. We recognize that some communication may be necessary for legal matters, shared custody, or genuine welfare concerns. Ending direct contact does not mean the situation is ignored. Instead, the communication must shift into a structured framework. Necessary information should be exchanged through a neutral bridge, such as a third-party mediator or legal representation. This bridge removes the emotional volatility from the exchange and protects the sender from further harassment claims. By replacing direct messaging with a neutral third party, you move from a position of legal risk to one of controlled, protected action. Managing the emotional difficulty of family harassment accusations is difficult to do alone. Professional, structured intervention can resolve these chaotic disputes. Cohen-Davis solicitors provide specialized harassment defense and support. Our team includes police station advisors with 20 years of experience. You can reach us at 0800-612-7211 or visit harassmentlawyer.co.uk. Resolving online family harassment requires an objective legal strategy, not emotional persistence.